Hey out there, legal warriors. Fishing in Washington State, shellfishing in Washington State, crabbing, shrimping. That's some very popular activities for people, for sports people, for families out for a nice day or nice weekend. And there's so many ways to make a mistake when it comes to fishing in Washington State. And one big way is a crime called unlawful recreational fishing in the first degree. In this video, I'm going to cover what it is, mistakes that are commonly made, what some defenses are, and how it is you can try to solve your case in case you get stuck in a very bad situation. If you're interested in this area of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. My law firm has been defending people charged with crimes all throughout Washington State for more than 20 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get to see it and get the help they need. That's just going to jump right into it. There's a bunch of different fishing laws in Washington State, but the one we see charged the most is unlawful recreational fishing and in the first degree. Now, the RCW for that, I'm going to take a look at my monitor here real quick. Hard to remember. RCW 77.15.370. And that is a very common crime. It's a gross misdemeanor crime, which means the maximum penalty is a $5,000 fine and 1 year in jail. And there's a whole bunch of different penalties that can happen with that, enhancements, lots of things. And in this video, I'm going to cover what's the general definitions we have to worry about for unlawful recreational fishing. Number two, what are situations where it happens? That's what we care about. And number three, if you happen to be in a situation where you're charged with this or someone you know is, what do we do about it? What are defenses? What are reductions? How might we have this turn out to be not such a negative event because it's a criminal matter? So getting right into it. Unlawful recreational fishing first degree is typically thought of and most commonly charged as having 2 or more times the possession or bag limit of fish or shellfish otherwise, legally taken here in Washington State. So if the limit were to be 40 of a certain species and you had 81, well, that would be 2 or more times the bag limit. So it'd be a first degree violation. Unlawful recreational fishing first degree. If the limit were 40 and you had 60, well, that wouldn't be a first degree, it'd be unlawful recreational fishing in the second degree, a lesser violation with lesser penalties and lesser maximums. Well, what if the limit was 0 and you just had the wrong species, right? You've got the totally wrong type of fish, you made a mistake. Well, the limit's 0 and you have 1, well, 1 is more than twice of 0, obviously, so that would also be unlawful recreational fishing first degree. So there's another way you can be charged with that, a whole bunch of ways, but a common way would be snagging or gaffing, right? It's salmon season and the salmon are spawning. You throw your rod out there and you pull it in and you catch the salmon not in the mouth. We've seen plenty of cases like this. I've had a lot of it in my time that I've defended. If the salmon isn't hooked in the mouth and there's evidence it was hooked somewhere else, even if it was otherwise legal, they're going to say, hey, that violates the law. That's unlawful recreational fishing in the first degree. Fishing in a fishway, there's a bunch of different ways that we can get in trouble for this. So what are the common situations that we see? Number two, where does this apply? Well, we have too many crabs or the wrong type of crab or undersized crabs, things like that. It can happen there. Too many shrimp, that happens all the time, right? We're out shrimping and we pull up our pot and there's an amazing bounty of shrimp and we end up, losing our mind and having too many. Too many clams, right? That happens so much. There's so many different types of clams and there's lots of technical rules about how we can clam and not clam the same way with shrimping, crabbing, generally fishing, and lots of ways we can make mistakes where we don't intend to. So those are some common areas where this could apply, right? General fish, shellfish, and clams as well. So what are some of the mistakes that I see out there when we didn't intend to make any mistakes? Well, for the most part, the law says that we can't possess or take these different types of species of fish or shellfish. So And us people out there in the world, we want to use common sense. Well, I'm going to sort them, and I'm going to sort them once I get to shore, or I'm going to, put them all in this bucket and then sort them afterwards. And common sense, uh, sometimes, big surprise, doesn't apply to law enforcement, right? Um, I only see the bad cases. I don't see the ones. Let's assume that Fish and Wildlife does use common sense sometimes. That's an assumption that I don't see, because I only see people that come to me when they're charged with a crime, right? But the ones I often see is someone making a mistake. It's like, hey, I'm going to sort these crabs once I get farther off of this dock where I was, had my crab pot over here. I'm going to sort them over here. Well, you can't possess more than your limit, right? Or possess the wrong type, right? You can't pull in your shrimp and then, motor away and then sort them later because you possess the too many that whole time. And they're not going to believe you when you say, hey, I was going to sort them later, because the law covers them, right? It's typically possess or take. And so if we possess more than we're allowed, even for a moment, if that moment Fish and Wildlife happens upon us, they're going to cite us. Okay. They're not going to listen. I've seen a shrimping case where someone volunteered to pull up another boat's pots because their pot puller was broken, and they're in the process of pulling up the pots. The boats are next to each other. It clearly was not going to be kept by the Good Samaritan, but yet, hey, the Fish and Wildlife showed up. They already had their limit. They're pulling up another pot. They didn't listen. They just cited that person, right? And so we have to be careful if we want to not get charged with a crime when we weren't intending any harm. We need to maybe avoid assuming common sense will save us and try to do things more literally, even if it's inconvenient. So count your things, measure your things, do your things immediately so we don't enhance our risk of running into a Fish and Wildlife officer at a time when they will claim that we are possessing more than we're allowed to, even if we never intended to keep things, because these are regulatory crimes. You'll take a look at the statute. Intent is not an element in that statute, right? These are regulatory. So believe me, if they still need to prove you knew about it, right? That there's a willful action, but you need no intent to harm the animal. You need no intent to keep more than is allowed. It's possess. Okay, so we need to watch out for that. So let's jump into number 3. What do you do? What do you do if you get cited by Fish and Wildlife? Well, number 1 is don't panic. Okay, don't panic. It'll probably be a while before you have a court date. So assuming they cite you for unlawful recreational fishing first degree, that's a crime. And Fish and Wildlife they're not allowed, for the most part, to file that charge into court. Typically, that needs to go to a prosecuting attorney for them to decide what to file. Okay, and there's some reasons for that. There are broad reasons about jurisdiction and the way things used to be done regarding bail forfeitures, things you don't need to worry about, but they will be a delay. There will be a delay between the time you get your ticket from Fish and Wildlife, or they may tell you they're going to send you one, and the time you have to go to a court date. So that's when you're going to want to contact an attorney so they can try to help you. So the first court date you'll get once we have a court date is called an arraignment. And if you watch this channel, you know an arraignment is something where we're informed of the charges and we enter a plea of not guilty. We don't enter a plea of guilty, we enter a plea of not guilty. If you have an attorney, the attorney can waive that arraignment. So then there's a pretrial hearing next, and your attorney, public defender or private attorney, see if you qualify for a public defender, many people won't, your attorney will get the discovery, the evidence from the prosecutor. And that's when the attorney will show the evidence, and then we start to try to figure out how we can negotiate your case. So in a large number of unlawful recreational fishing cases, it's somebody's first offense, and usually, unless we have some out-of-control prosecutors, and we've ran into a few in our time, not happy with them, but usually a prosecutor can understand that most unlawful rec fishing cases aren't necessarily intentional. We weren't trying to take too many. We weren't trying to go open up a fish business and sell excess catch online. Usually it's a good person who's made an honest mistake or just got carried away. And there's oftentimes some things we can do to try to make sure we don't get convicted of the crime. What are some things that can happen? Well, how do we handle it? One, we could get the case reduced to an infraction so that it's not a crime. There's a handful of fishing infractions and shellfishing infractions that a prosecutor can change it to. Second thing, maybe it can get put on an SOC, a stipulated order of continuance. It's a contract between you and the government, where if you stay out of trouble and maybe do some affirmative actions like community service, then maybe you get a reduction to an infraction or dismissed altogether. There could be a diversion program or friendship diversion, some counties call it, where you maybe do some community service, stay out of trouble, case goes away afterwards. Things like that are ways we can avoid a mark on our criminal record. We can also end up with a deferred sentence. If you plead guilty, the judge can give you a deferred sentence, which means you're guilty for a period of time, then unguilty afterwards. And rest assured, even if you get found guilty of the charge, if you stay out of trouble, under current Washington law, you'll be able to vacate that conviction later and turn it into a non-conviction. Typically 3 years after the end of a probationary period, if you stay out of trouble, you can move to vacate that type of crime. And so if you have a 2-year probation, it would take 5 years to vacate it, 1-year probation, 3 years to vacate it. If you have no probation for some reason, you'd be able to get it vacated after 3 years if you stay out of trouble. So what are some defense things we can talk about? Well, your lack of any history, the fact that perhaps someone else was more responsible for you. If you're in a party of 5 people that was out there crabbing and you're just along for the ride and you didn't pull any crab and it's not your boat and you had nothing to do with it, yet they cited everybody, well, maybe you're not guilty of anything, right? So level of culpability, level of experience, past history, can they prove it, right? Was that crab really undersized? Where's the evidence from Fish and Wildlife that it was, right? So there's lots of different things that we can do. But the most important thing to remember is stay positive, because these aren't the most serious charges in the world. What do you want to be careful about? You want to be careful about if you have any prior fish and wildlife violations, even infractions. So the law generally states that if you get 3 or more convictions of most infractions and most crimes, pretty much think about it, 3 or more convictions of pretty much anything, within 10 years, they're going to suspend your right to fish and hunt for between 2 and 10 years. That's pretty bad. So if you have priors, be careful about what you agree to or not agree to, because it can and will affect your ability to hunt or fish for the future. And the final caveat, there's a couple exceptions for unlawful fishing first degree that can carry a wildlife penalty assessment. Certain types of fish that get taken that are more protected can cause multiple $1,000s of penalties, and also can lead to losses of rights if we don't pay those penalties. So talk to your attorney, but I just wanted to cover the main points for unlawful recreational fishing first degree. So be careful, get your licenses, follow the law, have fun, and realize these laws are out there to make sure that there's more fish and shellfish for us to have fun with next year. If you find this useful, hope you did. Please like and please subscribe. More people will get the help they need. More importantly, if you have a fishing case, wildlife case, criminal case in Washington State, feel free to reach out to my firm. We've been doing this for more than 20 years. We'll listen to what happened. We'll identify a way forward. We will be there for you. Thank you.